Morgen to Professor Stephen Kos der Bundeswehr in Universität München, because in Germany it is morning time over there. Second, good afternoon, Ms. Yani Purnawanti, SHSSLLM, Faculty of Law, University Erlangga. And the third, my friend, Mr. Satria Unggul Wicaksono Perkasa, lecturer from University Muhammadiyah of Surabaya. And the moderator, Mrs. Presistia, the student of law, Faculty of Muhammadiyah University of Surabaya. Good afternoon, ladies and gentlemen. The webinar participant, I hope you are all in the good heart. Alhamdulillah, thanks to the Allah. We can finally carry out this webinar and IOF course. This is our first step in establishing a mutual cooperation and relationship. In the near future, we hope to finish writing with the speaker that can be published in international journal. I hope this webinar will come with benefit to all of you. Amin ya rabbal alamin. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much.
Waalaikumsalam warahmatullahi wabarakatuh.
Thank you very much for the Dean for the opening ceremony. Entering the main fun of the presentation of the material will be delivered by Professor Stephen Kos. He is an alumnus of the doctoral program at Law of Faculty, University of Constance. Some of his publications include 1. Juristische Aspekte des Rating, co-author Prof. Dr. Eben Roth in Busken or Evelyn Handbuch Rating Wiesbaden. Ethnic and Social Responsibility in the Competition Law paper in the International Seminar, Developing Legal System to Promote Social Welfare at Trisakti University, Jakarta. And to Professor Stephen, time is yours.
Good morning, ladies and gentlemen. Selamat pagi semuanya. Saya bisa bikin konversasi sedikit di bahasa Indonesia, tapi untuk berpresentasi mungkin tidak cukup. Saya akan berbicara di bahasa Inggris sekarang. Tapi di bahasa Indonesia saya mau terima kasih atas board, commission. Board Commission dari Fakultas Hukum Universitas Muhammadiyah Surabaya. Saya suka berada di Surabaya. Saya sering di Surabaya di Unair sudah. Dan mungkin actually we wanted to make this in person this year. I promised to visit your faculty this year, but unfortunately the situation is like this. So we are even more international. We fly 1 hour to Jakarta and the next hour to Kuala Lumpur and then to I don't know where. But hopefully kita harap mungkin tahun depan bisa lakukan itu di badan dengan badan live. Tidak di computer. My topic today is a topic I work on already 1 year, and there were several aspects, artificial intelligence, and I was always very interested in artificial intelligence and ethic aspects of generally in ethic aspects in the law, especially in my research in Indonesia. Because here is a big interest in this connection, same like in my own country, in the connection between the ethic and the relation between the ethic, the moral as a difference to that, and modern disruptive developments. For the topic disruptive, you see that in my topic there is not the word disruptive, even if it is a very catchy word in Indonesia. Anyone loves to use the word disruption all the time, and I must say just for the beginning that disruption is actually, in my opinion, in the private law never happened. We have no disruption unless we have it now. And that is why the artificial intelligence is so interesting, not as a special topic in the technical law, but as a special topic in the general philosophy of law and in the general methodic of law. We can learn a lot of that for the future, as we have in the future different developments, such as the 3D printing, also the augmented reality. These are things we will have to integrate, and we will need methods to integrate it in a proper way. Now, let me start with my presentation to show you certain recent aspects of that, which partly show what is the disruptive element, the disruptive effect actually in this technical development, differentiated to the for example, the internet, which was also called disruptive, but honestly, the internet is not disruptive in the law. The internet was just accelerating the communication, but the forms of the law were totally perfectly applicable. Yeah, so we have our civil code from 1900. You use also a very old Dutch civil code, and the instruments, let's say the institutions of the civil code. Especially the contract, especially the legal declaration, all these instruments of the civil code are totally perfectly applicable in the law with the internet. Yeah, just the speed was changing. Now, to show you first, and I will make it very short because I don't like this kind of things too long. What is the meaning for the European Union from the point of view of the European Union of the artificial intelligence? It shows, by the way, also that Europe is very much behind. We can analyze why this is the case, but here you see the meaning of the artificial intelligence. In North America, we have investments to the artificial intelligence between 12 and 18 billion euro. Yeah, in Asia, between 6 and 9, and in Europe, between 2.4 and 3.2 billion euro investation. 6.5 to 12 trillion euro per year. It's the estimated influence of this automatizing and knowledge-based work and labor and use of robots and autonomous cars until 2025. And I may say that my university is leading in Germany in the development of autonomous driving cars in the engineering faculties. So we are very interested in this. And this is the estimation of 2016. So here we have the KI, the artificial intelligence patents. In United States, 1,863 patent applications 2019. In China, 1,085. So here China is not yet in front, and here in the EU we are quite innovative with 1,075 patent declarations in this time. So we have a 400% raise of the patent applications in the last decade. 60 million new labor jobs are dependent on this development in digital and in so-called green economy, which is the economy which is clean economy. Yeah. So first of all, because I want to talk a little bit, is always a meaning in the relation between the ethic and the artificial intelligence due to the decision of the European Parliament and the European Commission mentioned in the Weiss book, in the white book of the European Commission from February of this year, that we need an anthropocentric artificial intelligence. Anthropocentric is clearly connected to ethic. Now, I must talk a little bit about ethic and of moral, because in the discussions which I know from with colleagues in Indonesia, in the press in Indonesia, we often read a diffusion and a confusion between the moral and the ethic. I remember a journal article in the Jakarta Post in English language 3 years ago, I don't know if it's 3 years ago, from someone from the philosophical faculty in Binus University, who was asking whether the artificial intelligence has a separate ethic. And in the article, he confused the ethic with the moral. Now, the moral is not the same with the ethic. So when we talk here in the law, we cannot care for the moral. The moral is it's a monopoly concept. A monopoly concept, the monopoly of the individual, the monopoly of certain groups of the society. Whereas the ethic is a pluralist concept, which is the result of a pluralist decision between several morals, which are always in pluralistic societies arise, and an equilibration between these morals. Now, if we talk about ethic, we talk really about something different than about moral. It's not about moral, it's not about my moral, it's not about your moral, it's not about Christian or Muslim moral. It's about ethic, which is a pluralistic concept which should unite an agreement in the society about rules for the society, which can be, of course, different than the separate moral rules of parts of the society, which have a meaning, but cannot stand over the ethic of the legal system and of the society. So ethic is a pluralist concept, and if we see the ethic in Aristotle, this is not very important for my presentation, but I liked it. Sorry, this drawing here, I can obviously draw here when I move my mouse. Human being is a social being longing for happiness. Human being is rational and able to act according to rational decisions. Human being as social being is happy in harmonic societies. Human societies can only work if its members act in a social way, not in reckless egoism. Therefore, it's rational to act virtuous. That's just for the end for this topic of the ethic. Now, if we talk about the ethic of the artificial intelligence, or the possible ethic of the artificial intelligence, then I always use in my lectures the Abraham's temptation. The AI as decider over life and death. We can see these situations, for example, in the autonomous driving, when a car has to decide to protect the driver by colliding rather with a soft goal, with a pedestrian in the street, with a person in the street, than to collide with a fixed wall, which would kill the driver. So the car has a decision. Will I collide with a wall, or do I go to the right side and then collide with 10 people in the street? Which would save the driver, but of course not the people in the street. Now, Abraham's temptation is quite teaching for us here. Abraham had to decide when God said, you have the decision. Let's make it a little bit more modern. God says to us, you have to decide. You kill this baby, which is innocent, lying in front of you, or you kill 1,000 people, which are also more or less innocent. But if you kill the 1,000 people, then the world is have 1,000 people less, because these people will be dead. Or you kill your son, then only one person will die. So you have the dilemma: killing the innocent child or kill 1,000 people. If you kill innocent child, you will not save 1,000 people, and 1,000 people are more than one person. 1,000 people are one world's. One souls, 1,000 souls against one soul. What would we decide? Now, if I ask my students, what would you decide? Let's say it's not your son, it's just a child you don't know, but this child is cute. This child looks at you with the big eyes. What would you do? And then most of the students, mostly the males, say, of course, it's clear, it's logic. Yeah, I've saved 1,000 people, and because then I must do something what we have to do. Yeah. Mostly the women say, oh, I don't know, maybe I cannot decide that, and so on and so on. This is very clear. And then when I dig a little bit deeper, then often they say, but I'm not sure that in the moment when I have to raise my dagger and kill this child, would I really do it? Maybe we would not. I cannot say what I would do. Maybe in the last moment I would say, God, why you give me this decision? I don't want to have this decision. Yeah, so I cannot say it. Really, it cannot say. This is exactly what artificial intelligence differentiates from us. The human being cannot be foreseen. We cannot say with a reckless person, which is normally reckless, will this person in this moment really decide against the child? And will it be able to kill the child to make this bloodshed for saving 1,000 people because so rational or not. We cannot say that. It is possible that in the last moment there will be the decision taken overruled by another decision. It can be that the person is not having good perception and does not really calculate good. It can be that the person is sleepy, or the person has a good mood and the person has a bad mood, and then the decision will be different. But what we can say is that an algorithm who is programmed in a certain way to decide in a certain way will not have doubts. There is no doubt in an algorithm. The algorithm can be programmed to make randomized decision. And we don't know, we cannot foresee it, but this is not a doubt. This is a randomized number. There's a number and the randomized number says 1 or says 0. If it's 0, then it kills the child. If it's 1, then not. But this is not a dilemma the algorithm has. And the algorithm will also not be in bad mood or sleep bad in the night and then decide different. So the algorithm cannot be foreseen. The judge cannot be foreseen. The algorithm can be foreseen. The algorithm is programmed. And the algorithm can be programmed to, in any case, save children. And it will not kill the child even if 1,000 people die. The algorithm can be programmed to, in any case, be rational and save as many people in the society as possible. Then the algorithm will not doubt that it has to kill the child. So what we can see here, imperfect algorithm, imperfect artificial intelligence is not possible. Artificial intelligence is in a way always perfect. Well, if you talk with the KI developers, they will say, no, our artificial intelligence is more and more perfect because it can learn. But learning is not perfection. Perfection is exactly given if an entity is acting in a certain developed and a certain programmed way, which is not the case in a human. An imperfect artificial intelligence cannot feel. If an artificial intelligence would feel, then it was not imperfect. And if the artificial intelligence could feel, then we must be very afraid of the artificial intelligence, because then we cannot rule the artificial intelligence anymore. So it is hardly in the definition that artificial intelligence cannot have this dilemma. This is very important if we ask how should artificial intelligence decide and which power the AI should have to decide. If we take the example of the autonomous driving, we see exactly the dilemma. Should I kill my driver by driving against the wall? Or should I kill the people in the street? Then I would protect my driver. Now, can artificial intelligence replace judges? This is the consecutive question to this. I was discussing with a colleague from Finland in a conference some years ago, who told me, yeah, Stefan, I'm sorry, he was not a lawyer. He said, I'm sorry, the lawyer will be not necessary anymore. We will not have judges, we will not have lawyers anymore. We will have expert programs, artificial intelligence judges, which are much better because they don't make mistakes and they decide always in a fair way. They are not corrupt, unless they are programmed corrupt. But they cannot be really corrupt because, again, they cannot have wishes, they cannot have desires. So the artificial intelligence will be the best judge and will be better judge than a human judge. Is this to agree? Now, if we think about that, then on the first side, yes, this is very, very striking. Yeah, a judge can have slept bad. A judge, I was myself a judge. I know how difficult it is sometimes to concentrate if you have a bad day or you did not sleep good or you cannot stand the accused person in front of you especially, yeah, but you must stay objective. Now, no human being can ever be totally objective, but we can, of course, follow the rules. But I cannot be sure that my decision was not always biased. Yeah, the biasing is a big topic if you talk about the decision of judges. Now, the preamble of the German Basic Law, which is our constitution, is saying, conscious of their responsibility before God and man, inspired by the determination to promote world peace as an equal partner in a united Europe, German people, in the exercise of their constituent power, have adopted this basic law. Now, this reference to God is not to understand as a reference to God in a way that the German government would or the German state would be a state which is connected to religion. We are totally separated from religion. This decision of God or this reference to God is just a reference to something which is over positive, which is over human, no matter whether it is in the Islamic belief, in the Catholic belief, or in the Buddhist belief, or in the atheist belief. So also atheists must say there is something above human being, because otherwise we could change something very important, which is Article 1. Human dignity shall be inviolable. To respect and protect it shall be the duty of all state authority. So the government cannot change the binding to the human dignity. Human dignity is above all law, also above all law of the Constitution. And even if 90% of the people decided that the human dignity is not important, it could not be abandoned. So now we have a very important aspect, because we can now see whether the artificial intelligence, which would be a judge, would infringe maybe this rule. And I must say that it cannot be denied that a human being has the right to be judged by the faulty judge. My deed can only be judged by a human being, because I'm part of the society, and the society has to judge me, and not a cold algorithm has to judge me. If we see algorithms, how they judge, they will not give me the chance to convince them. They will not give me the chance to tell them, well, yes, I killed the person, but I had a different reason, because the person was maybe torturing me over 20 years. What will the artificial intelligence do with that? So the cold decision of an artificial intelligence judge, in my opinion, is not compatible with the Article 1, which is in all the constitutions, I'm sure also in your constitution, with the guarantee of the human dignity. So it is part of the human dignity to be decided, to be judged by a human judge, and not finally by a artificial intelligence. By the way, in Indonesia, there's the discussion whether artificial intelligence should be used as the law and for the law firms and for the notary. There is something very similar. If you use expert systems in the court as a judge, then expert systems which say, okay, after the proof were heard, the AI say 90% the delinquent is guilty, then you are biased as a judge. So I also would say judges should also not use these expert systems to measure the meaning of testimonies of witnesses and so on and proofs. So artificial intelligence is perfect. Human is not perfect. Human do mistake. Human can be biased. Humans have feeling. So there is not a way to accept artificial intelligence judges in a total way. And also you all are legal experts. You know legal rules might have to be adapted to exceptional or new situations until no application, teleological reduction to zero. How an AI will do this? Application of law is not static. It needs the capacity to draw analog decisions. This is something, in my opinion, artificial intelligence cannot make. Let's come to another aspect, which is in a moment one of my most important or most interesting research areas, because we are preparing a critique of the data protection law in Europe. In the light of the innovation support, artificial intelligence and big data. What is the problem? The problem is, if you have online shopping, just as an example, you can use artificial intelligence to collect the data of the consumers and then use this data not only for procedural reasons or for the purpose of the contracting, use this data for making profiles of consumers or also of concurrents, and then process it, and then you have profiles, and these profiles you can use to influence the consumers, to influence, even if you see in Facebook, even to influence the political situation in certain countries, influence votes, and also use it for discriminating prices between consumers by algorithmic pricing. Now, processing of big amounts of personal data from data mining companies, this is a future market. I mean, if you talk about Facebook, this is not the market in the moment. The market of Facebook, of the social media, is not so interesting. When we talk about the market of Facebook, we must talk about data mining company, and this mined goods, this data is not yet really in a big market. The market is still to develop. Yeah, we don't know in the economy what is the measuring, what is the valuing of the market of the data. What is the value of your or my personal data? We don't know that yet. So this is the product they mine. And once it is mined enough, and once we have the analytics of the AI in a certain way and in a very developed way, then this data will be really reasonable, valuable. And then they will use this big data, Facebook, Google, Apple, and so on, they will use this big data to combine it with their artificial intelligence, with their developed artificial intelligence, and then they will be able to really influence markets and to really influence societies. And this is not yet really developed. It will come. And this is very important to know. So how we deal with artificial intelligence. One thing is clear, that big data and artificial intelligence is very dangerous. One thing is clear, that there is data protection. And but one thing is also clear, that we are not, you not, Indonesia not, Germany not, are not islands of happiness. Yeah. So even if we decided we want to, in any case, protect the consumers, protect the population in a classic way against data use, even if that is the case, then we cannot say that it will work on long term, because data business, social media, all which is going on in the internet is ubiquity. Ubiquity means we don't have limits anymore. We have not border anymore. So the territoriality principle is switched off. So a country like Indonesia or Germany alone cannot limit the use of data in the territory, because it is not important, the territory of Indonesia or of Germany. Important is the world territory, because all is ubiquity in the free society. If we talk about China, of course, they have measures to limit maybe the reach of social media, but we haven't. So we have to decide about what we want to do. We have two ways. We can decide we stick with the traditional and classic protection of data and make it very restrictive in a prohibitive way. That is our first way. If we do this, then we would, of course, not very much encourage the development of this new technology. Or we decide we cannot at all fight against the development of this new technology. So we should develop it and should give also incentive to develop it in our countries, but find a way how we can equilibrate the interest of the individual to be protected against that with this interest of the innovation. So I don't want to go too much into the deep. This would be a presentation of its own. The way will be, I'm sure, to go away from the prohibitive way of protecting data. It is forbidden to use the data in the HR management of the employees for make training data of the AI HR management system. It is forbidden to collect the data if the consumer did not agree, and so on and so. Think of all these cookie agreements and all these things. This is not for nothing, because we can see in the psychology that people are not caring for that. There is a paradoxon. The more data they give, the more they want to give. Yeah, and even if they know more, it is dangerous, they would give even more data. See it in Facebook, how many data the people give, they know Facebook is dangerous. So they will not work. So what we need is a shift from prohibitive data protection to participant data protection, to understand data as intellectual property, for example, in a license model, and then make an equilibrium between the interest of the individual to protect the data and the interest of the society to develop modern forms of technology and modern forms of, for example, the HR management with artificial intelligence systems. This is the most important and most interesting aspect in the moment. Concerted behavior of AI entities in the market is very, very interesting, structurally interesting, because we have cases where AI systems, algorithm, already decided about prices. For example, some years ago, when a domestic airline was going bankrupt, then the German airline Lufthansa raised the price within seconds. Why? Because the AI observed the market and decided there is a different competition situation, and then adapted the prices at once automatically without any influence of a human being. Now, in the antitrust law, this is a problem. This is a pricing, and we must, of course, say this is not a cartel pricing, because Lufthansa was not talking with other companies to adapt the price, but it is something very similar. At least we can say it is maybe same damage to the competition, like if we have a concerted pricing. So we have to define forbidden concerted behavior related to action of algorithm. Can algorithm, for example, collaborate? So German airline Lufthansa has an algorithm, and Garuda has an algorithm, KLM has an algorithm, and the algorithm collaborate to regulate the market. And if then the KPPU or the Bundeskartellamt comes to that and said that is forbidden behavior, then they say there is no behavior. Why no behavior? Because it's an artificial intelligence. This is not is not a person. Only person can behave. Can algorithms behave? This is the problem. So if we have no behavior, we have no antitrust law. And we have no antitrust law to apply, we have a problem. And that is something KPPU in the moment also sees. So what we'll need is a new definition about the term of behavior, and maybe a sui generis term for behavior, for acting of algorithms in the market. And we need to decide who is responsible for market acting of algorithms. Who is responsible if algorithms harm the market? This is a question of personification of technical entities. Can the entity itself be a legal subject to be responsible? Then we must talk about different things also, because we need liability assets and so on and so on. So this is a question of the law of persons. Or do we have an agent represented model? So the artificial intelligence is acting like an employee, and we put the responsibility of this entity, of the AI entity, to the owner or to the beneficiary of this acting. Yeah, it means to the company. Lufthansa said we are not responsible. This is not our responsibility. It was our algorithm. Bundeskartellamt is now thinking about exactly amending this, giving responsibility for this to the company. So how to regulate that? A pragmatic way for the first place would be make the burden of proof of non-harming of the market to the company. Now we come to the crucial methodological part, and this is the most important part in my presentation now, because it shows the disruption. Contracts by AI. Can AI make contracts in the private law? Now, my opinion, to make it short, is we cannot in the moment integrate AI contracting, machine contracting in our, and the same applies to your own private law, in our private law. We cannot. Why? Now, the contract is based on the elements of the contractual intent and of the contractual will. Contractual intent again is based on a basic principle of the private autonomy, at least in the liberal society, which have Dutch private code. All this is based on private autonomy. Private autonomy can, of course, like my students often see that, seen very pragmatical. Oh yeah, I'm free to make contract, yeah, and maybe limited to the contracting. But private autonomy is much more than just a question of freedom of contracting with whom I want, with what topic I want, or about what I want. Private autonomy is nevertheless, as the private code is pre-constitutional, it was from 1900, our constitution is from 1949, private autonomy is based in the constitution. Private autonomy is an instrument of personal freedom of the legal subject. It is not standing apart or standing separate from the constitutional freedoms of the individual in the constitution, in the society. The society has several aspects where it should be free. One aspect, for example, is I should be free in my family. I should be free to say what I want. I should be free to free speech. I have freedom of religion, and so on. But another aspect is I need an instrument of freedom also in the traffic of the law. I need an instrument to express me and to express my intents and my desires by making contracts. I have the desire to buy a car, so I can make a free contract. If it was not free, if the state should say, no, there is a group, a person cannot make contracts. This is the limiting of freedom. So private autonomy is instrument of personal freedom, and therefore it is connected with the legal subject, with the constitution protection of the legal subject, and more important, with the aspect of the subjective right. The subjective right is the basic instrument of the legal subject. I have subjective rights, rights which are assigned to me as a legal subject. Now, human being can wish and human being can have desires. Without desire and without wish, there cannot be a will or an intent. So human being can have intent and will. So human being can have also a contractual intent, but AI cannot have a contractual intent because AI cannot wish and AI cannot desire, and therefore AI is not free. So AI does not need only not the personal freedom of the private code. AI is not able to be integrated in the institute of the private autonomy and the private will in the contracting law. That is why we must say that the integration of AI contracts, if it is in a perfect way and if it is in a consequent way, is not be able to be done by analogy. We cannot just make analogy to the private autonomy or to the contractual intent system which we have nowadays in our contract, in our private code, because this autonomy would go far over the limits of analogy. Sorry, it would be far over the limits of analogy, which is technical, legal technique, and the right legal technique. We cannot do that, because if we do this, if we make an analogy to the human private contractual intent, then we give up the connection between contractual intent and private autonomy, and therefore the connection between private autonomy and constitution and private freedom. And this is, in my opinion, a big disruption. This would be really a disruption. So the question is, what could we do? So we have in the moment not yet this problem. This is more or less science fiction in the moment, because in the moment the artificial intelligence is not strong. So as it's not strong, we can always say, if you have a algorithm acting in a certain way, you're programmed, then you can still say there is a certain connection to the programmer or to the owner of the AI system or to the beneficiary. So if the AI make a contract on the behalf of me, then it is still possible to say, okay, this is just an agent of me, yeah, in the agent theory. But as soon as AI is more independent, deciding without any influencing of a human being, then we have the real disruption, and then we need something. We need a new concept, how to integrate that. So in my opinion, we need a new category of contractual actions for this independent AI. And I can tell you this is already done. If we talk about smart contracts are algorithms which are programmed in a certain way to act in a certain way when certain conditions are done. This is not much more in the moment than a vending machine. A vending machine is also programmed. You put the money in, and then the vending machine gives you chocolate. Yeah, this is more or less in the moment a smart contract. But if we combine the smart contracts, the blockchain smart contracts with artificial intelligence, autonomous learning and deep learning and thinking, deciding and flexible deciding, then we have totally independent acting unities, which are totally independent making contracts. And then we cannot assign this contracting to a person. And then we need a new category of contractual actions to not disturb and not destroy our system of the personal freedom and the private autonomy. The same will apply to the market influencing acting. We need a new concept of competition acting, which is not connected to the behavior term anymore. Now, the easiest way is to say we need this. The difficult way is to say how we do it. Yeah, so we will need, of course, rules which protect the human being in the traffic, in the legal traffic. Yeah, so we cannot just say, okay, the AI can do this, and this is a new category, and the AI does it. and then the human actor is in a worse position. Yeah. So, example, the human actor who make a contract. If I make a contract with you, then I should not lie to you. If I lie to you, then maybe you have the right later to annul the contract because I lied to you, because you trust me. Trust is a very important aspect in the contracting. Yeah. But if we have AI contracting, machine contracting, how we integrate trust, how I integrate trust if a human being is contracting with a machine, and how we want to handle deceiving. Yeah, machines cannot deceive. Yeah, but maybe there is a wrong programming or whatever. How we handle that? This is for this presentation, of course, much to decide, and we can maybe discuss about that. But this is a big topic for the research in the future. Do we need a personification concept of technical entities that would make, on the first side, something easier? So the AI is the person. So we have a juridical person, a juridical person, a legal person. We have the natural person, we have the legal person, the associations and the foundations, and then we would have the technical person. This is not longer science fiction. The European Parliament already in 2016 proposed to the member states of the European Union to regulate a technical person. A technical person would not solve all our problem, but a technical person could make contracts. But nevertheless, we have the problem of the protection of the market against acting of these units. We have the problem of the liability assets, could be founding or whatever. But this is, in a moment, quite difficult to decide. Let's, in the end, put a look on the personification topic. Can be AI personified? I mean, in the Islamic law, I think you also know the discussion between the simulated legal person. So a legal person is a fiction of a person or a natural concept of the personification. So the legal person is a legal person because it has the quality of a person. So this is, of course, discussed also in the traditional European law situation, especially in Germany. In the German law tradition, already in the 19th century, we discussed that. And actually, the German code is based on the fiction theory. So if I say here, phones are often used in a bad way, let's protect the phone, then the legislator can, of course, say, let's make a law for the protection of phones. And Article 1 of this law is phones are legal person. Yeah, we can do that. Whether that is a good law or not is a different question. Whether the people would accept that is a different question. This is the question of a good law, but it is possible to make that, to regulate it. Or we say, no, a phone can never be a legal person because a phone has no parallels and nothing similar to a human being. So why is a society, why is an association, why is a legal person? Because there is a group of persons who have a will. And this is a legal intent, a legal will. So it is okay to say, okay, from the reality theory, we say the group is a legal person. Same happened to the foundation. There is the intent of the founder. So we have a parallel to humanity. Even animals, we could say maybe animals can feel, and so why not make it a legal person? But an AI has nothing, no parallel to a human being. There's no legal intent. There's no feeling. There's no desire. So an AI in the natural theory and cannot be a legal person. Only in the fiction theory could be a legal person. With that, we could solve certain problems, but not all problems, as I already mentioned. For example, in the copyright and patent law, you all know this monkey making photos in the forest of Borneo, and then the question was, can that monkey have copyright? No, cannot, because it's not a legal person. The artificial intelligence already writes books, already can paint. Can there be a copyright to the legal person? If it's a legal person, of course it can. There are certain ways to do this, but we cannot go too much into the deep for this. So I don't want to do this. So the further question of that would be how we make it, the legal technique of the personification, fiction theory, natural theory, or use the law of associations like in America is done. They make a one-person liability company, a non-limited liability company. And the purpose of the company is the execution of the will of the AI. And then all the founders go out of the company. Then it's a no man's company, and the no man's company is only execute the will of the AI. This is already a legal person of AI. And it should be also acknowledged in Germany because we have an international private law asset contract with America, but it is of course against the ordre public, the public order. How we make the control, we cannot accept AI systems without any human control, and how we regulate the assets. Here in my presentation later, you will find all these rules I mentioned here, the legal theories, also the source of the recommendation of the Commission and of the European Parliament. Now, if we talk about the further development of the artificial intelligence in Europe, then I would like to give you in the end just in short outview what is coming up here. And I must say, even if we are sometimes a little bit critical to our European legislation, Europe is quite modern in many ways. We have the first amendment now for artificial intelligence acting in our antitrust law. We are thinking about a token law, so a blockchain token will be regulated in the European Union, and we have now a big initiative in the European Commission and the Parliament to regulate AI entities. And AI entities itself cannot be regulated by European Union because this is a competence of the member states, but there can be corner rules be defined. So we have the report of the European Parliament I already mentioned. Then we have a communication from the Commission to the European Parliament, the Council, building trust in human-centric artificial intelligence. This is the premise, making a human-centric AI. We have a white paper on artificial intelligence from February 2020. It's all in English, so you can all find this free source in the internet to read that. And we have a legislative proposal
Sorry, Prof.
on this topic. So you have find here all the references. Also very interesting for you if you're interested in this topic. The two articles of Mr. Sean Bayern from United States, together with a colleague of mine from Switzerland, Thomas Bury, about how to integrate AI by the means of the law of associations. My own article in Malaysian Journal of Sharia and Law, also all open source. A very short article, the first article I done, and I can already mention in January there will come a new article of mine in Erlanger Law Faculty magazine Juridica on all these aspects, a longer article on all these aspects of artificial intelligence, including the influence on the antitrust law. So let's put the rest to the Q&A session. I hope it was not too long. And so let me finish with that by thank you for your attention.
Okay, thank you very much, Prof, for the presentation about artificial intelligence, legal, ethnic, and private law. And for the next speaker was Mrs. Jani Purwanti, Master of Law. He is a lecturer at Faculty of Law, Erlangga University, and has held several positions, including Assistant Professor at Faculty of Law, Erlangga University, Field Coordinator for Human Trafficking Project in Erlangga University, and also she has collaboration with University of Science and Management Malaysia. And to Mrs. Jenny, time is yours.
Thank you so much, the moderator, for the times that given to me. Good morning for Professor Stefan Kos in Germany, and good afternoon to all my colleagues in all over Indonesia. I think I noticed that you come from Sumatra. Universitas Bung Hatta is there. Is many other universities gathered in this very special occasion. And first of all, I will congratulate Universitas Muhammadiyah Surabaya for successfully holding this seminar, and also it is an honor for me to be part of this seminar. So thanks to be being the second speakers after listening what Professor Kos already mentioned and presented in a comprehensive way. So I'm so released because part of my job is already done by Professor Stephen. So I'm just continue a little bit on the perspective of bioethics. So here is before I start my presentation. Before I start my presentation, so I will once again back to what before Professor Stephen Kos already mentioned, that right now European Union is has so many what is that? The progressive movement in legal reforms. I noticed that. I also learned about e-commerce law and also European Union proposing a new e-commerce law. And I know here is what I want to share to you as a beginning of my presentation. Moment. Okay.
It's not just science fiction. Powerful machines and algorithms are already capable of diagnosing illnesses, performing surgery, and driving autonomous cars. These technologies provide us with new tools and disrupt the way we work. Yet no one can tell what impact artificial intelligence will have on society.
I think that we need to have ethical and fundamental rights impact assessment, how the functioning of artificial intelligence will influence on many issues which are important for our everyday life.
We have invested a lot of hope in these new technologies, especially for healthcare and decision-making processes. But artificial intelligence also raises ethical and legal questions. For instance, could the development of new AI applications be a threat to human rights?
Should individuals have to go through facial recognition or affect recognition when an AI can recognize or predict your emotional state in a job interview? So I would agree that right now we need to do more of the work of understanding what is going on before we create regulation and policy.
This means we can set global standards also for artificial intelligence to make sure there are some ethical rules that everybody would follow, to accept that we will not use AI, weaponized AI, and against humanity. It will be complement and not replace humans. We will not develop consciousness.
These questions were at the centre of a recent meeting of experts in Brussels, organised by the European Parliament's panel for the future of science and technology, STOA. The gathering shed light on proven cases of human rights violations by AI and highlighted potential responses to risks. For example, ethics frameworks, regulatory oversight and legal safeguards could help us to avoid the misuse of artificial intelligence.
Yes, this is a short video that giving the information of us what happened outside Indonesia and how European Parliament now is active in proposing I'm sorry. So here the video show us that what happened in outside Indonesia, that European Parliament now is proposing that there should be encouraged the global community to accept to agree on certain rules and ethics regarding AI. So here is I will start my presentation by showing you my okay. So I think I'm just repeating a little bit what Professor Kos already explains in the first session. So if we are asked what is AI, so I think I can propose three simple explanation what AI is. So AI is a different kind of human level intelligence within machine and using computer to solve problem or to make automated decision for those tasks when done by human typically require intelligence. Or the third explanation what to explain AI is a field of computer science. AI is the creation of the machine that can think, learn, react like a human. So it's an interesting history that I found out that AI is firstly introduced in 1955 in Dermot Summer Research Project on Artificial Intelligence. So here is our fellows who is a pioneer of AI back in 1950s. So I think you can see here is they are from Dermot College, Harvard University, IBM Corporation, and Bell Telephone Laboratories. And it is, I'm sure that they already predicted in next 10 or 50 half of the century. So AI became something a big issue in our life. So okay, so what is AI in our today life? So here is we have to admit that we are living in a society with an artificial intelligence among us. So one of the problems when it comes, which is the idea of the ethic versus morality, because you know that since we are growing as a human being, our life are pretty early on shaped by moral and ethic, whether we realize it or not. But we know that computer that we create will not just to be a computer that mirrors our own rationality. So if we are not careful, it can start to take a decision that sound rational to the computer and to the people who program it, but perhaps it can be anti-human. So here is with the AI among us. So we move to the dysentery toward autonomous general intelligence, autonomous machine that can affect or evolve the life of human beings. So AI is giving us a lot of a really great application that providing a lot of benefit in a lot of areas. So, and here we know that we are living with AI, with digital technology, with networks automatic. So it is not only, it is our future life, but artificial intelligence move out, come out from the laboratorium and become a realm world. So more and more people are becoming aware of some ethical concern that kind of go along with some this of application. So I think after this slide, I will show you what is the ethical issue arise when we are talking about the AI application in our society. The first one is, so we know that when our scientists created AI, that the initial purpose is to help people in healthcare, to monitor people in healthcare. So so when they get collapsed, then he can get the the assistant in a very quick way. But in the same time as well, the same technology can be taken out and put into smart bomb to track people, or also can monitor people go around. So this is kind of the things that, you know, that as we know that if we are talking about a knife, so that have to be a two-sided. So we need to figure out when we are developing this AI or algorithms that are potential outcome that we don't necessarily expect. And here is this is usually implanted by a person who already have a surgery for the heart, but that's implant technology also used to track, to put a bomb. This is to put a bomb, and it is to shoot something else and for the military purposes. The second big issue is, you know, that AI always involving a faster and bigger and also expensive machine. So just guess who can afford to buy that kind of machine. So only people who can afford this machine can have they are usually a big company. So this means that fewer and fewer people actually can control the destiny of artificial intelligence. And we as a society want to know how AI will be used to benefit our society in the future. So AI is not only invented and also accessed by a minority. And the third one is, AI, as Professor Stephen Kos said, that cannot have an intention, cannot have the thing that usually human has. So AI doesn't exactly think the way that we do, and it doesn't necessarily share our value. So because of this, so the risk isn't that AI will be malicious against us, but also the risk is also AI will do exactly what we tell to do, and it will do it in the way we don't expect. It is a real danger. So the problem is that we tell AI that we want, but we define it in a vague way or unclear way, so that AI just do what we ask to do, and it will find a way to do what we tell because it doesn't share our value. So it will do things that are unexpected. So here is I'm going to talk about bias that could be done by AI. So if we don't tell the artificial intelligence that we don't appreciate bias against certain ethnic groups or gender or so on, so AI might inherently adopt bias from whatever data it gathers. So in this situation, we need to figure out ways to limit the effect to make sure that the data we provide to AI is as free as possible, and also to look at the behavior that AI and sort of to mitigate against the risk that sort of the alignment behavior causes. So there's three major problems when we apply AI in the society. And for the next the next step, I will introduce you what is bioethics. And after I'm talking about bioethics in social science setting, then I'm trying to connect how bioethic relate to AI problems when it is implemented in the society. So bioethics refer to the subject area and problematic areas of human life and healthcare, with an understanding that it applies not only to the doctor-patient level, but also broadly to public health and humanities, as well as ecological problems like climate change. So it is a multidisciplinary approach, different approach to those problematic situations. So it is important to have people from science, social science, and humanity. So we are from social science and so from humanity also need to know what bioethics is. Even we know that bioethics is mainly applied in health science and medical science, and bioethics is a backbone of that science. But as we are a social science and the object and as well as the same time the subject of the research of the social science is a human being. So I think even though social science usually set aside when we are talking about bioethics, but actually social science has a very close relationship with bioethics. So finally, bioethics is always important to have plurality of view to reflect many possible ways of interpretation and potential solution. So my three next slide is still elaborating about bioethics, but I think I'm just want to give you an example what is bioethics. Actually, maybe we know bioethics already, right? So when we are studying in a law school, so the decision to whether it is allowed or not allowed to do euthanasia is a discussion on bioethics issue. So whether if the medical technology can detect the janin, the baby inside the wombs is maybe have potential to be a disabled person. So whether we will continue to carry her under and give birth, or we terminate the pregnancy. And whether we decided the death is based on the failure of the heart or the failure of the brain. So that's part of the issues. What is a conventional issue when we are talking about bioethical only as a what is that as an easy example to understand that. So that is bioethics. So then you can read it by yourself here. So bioethics usually this problematic decision lead to conflicting. So when we are talking ethics, so ethics is always placed when we have a dilemma. So when we have a dilemma, so we have to consider all the possible good way, as Professor Stephen Kos already mentioned in the beginning of his presentation. So whether we sacrifice one innocent boy to save 1,000 lives. So then what bioethics propose is we must choose one scenario that is less bad than the other one. So we are not talking about good scenario very often. And again, bioethics is a multidisciplinary factor. So there are different disciplines related to the discussion on problematic issue. So here is my chance to encourage all of you from social science and also from law to start studying about what bioethics is. Because you know that I believe that when we know about bioethics and try to search the connection with social science and humaniora, so then we will, you know, that we will reach the essence, the understanding of the essence of the social science better. Here, I will introduce you with the Universal Declaration of Bioethics and Human Rights, enacted on 19 October 2005. So here are the 13 principles of bioethics. So the good news is, you know, ethics sometimes is only applied in certain geographical and also certain society. But bioethics, by this Universal Declaration, is the acceptability is more universal and more worldwide. So what we are going to do with bioethics? So this done with the bioethics, then this is I'm going to talk about bioethics in social science. Yes, indeed, the backbone and the core issue on bioethics is on health and medical science. So that health and medical science is a solid and well established because they use bioethics in their daily professional life. Yes, we have to accept that social science is far left behind if an even relation of bioethics and social science is so close. Why is it so close? Because subject of bioethics is human being, and human being is also the main actor in the society, and the society and the human beings are the object as well as the subject in the social science. So engaging and involving bioethics in study of social science will ease and accelerate the well order of the society. So here is the place where I'm trying to connect bioethics and AI. So back against what is proposed, what is currently proposed by European parliaments. Also, they are saying that there should be ethics that obeyed by all the international society regarding the use of AI. So I think we all need to have open the big discussion about what AI can do, what it cannot do. And the second one is how we can manipulate things to make sure that AI can be used for the benefit of as many as people possible. And the third one is to minimize risk and damage of AI usage without discouraging the unstoppable innovation and advancement of technology. How to do it? So I think GARD AI application with ethics consideration that can be applied universally. The second one is empowering people with knowledge and ability to adapt the AI to be part of and to support their life on the level of AI as they need it. So I think here is before pandemic, the new issue in 2020 about revolution industry 4.0 or 5.0. I think the emergence of technology is involving densely in our life. So, but here, then here is the fact. Maybe after we're done with the pandemic, then we are entering another round, another version of our life where we cannot avoid the presence of technology, and within the technology, it is run by AI. So I think as a common people, we do not need to know about the high sophisticated AI, but I think we have to familiar ourselves with AI that we need to support the quality of our life. So the guarding AI application with ethic consideration can be applied universally. So I think here says I offer you that bioethic principles are deemed as a value that can be accepted universally. So it deals with many aspects of issue relevant to application of AI in the society, and to open an intense discussion need to be carried out so that we all together, especially in our position as academicians, can contribute to the wellness and the well-being of the society by promoting and articulating ethic usage in AI application. So I think in this very honor opportunity, I think maybe I will ask Universitas Muhammadiyah and all the partners to start talking about what is an issue. We need to make ourselves get used to with the ethical issue when we are talking about AI. So I think that will be an evergreen topic that if we can have a group of discussion talking about the ethics in the usage of the AI application. So this is this is the end of my presentation. Thank you so much for your attention and your patience in listening to my presentation. Return the mic to the moderator. Thank you very much.
Okay, thank you very much, Mrs. Jenny. And we will continue with the next speaker, Mrs. Dr. Asri Wijayanti. She is an alumnus of the Airlangga University Faculty of Law doctoral program. Currently, she serves as the Dean of Faculty of Law, Muhammadiyah University of Surabaya, and she is active as head of P3HTI. She has produced several scientific works and books in the field of labor. And to Mrs. Asri Wijayanti, time is yours.
Ma, kunci motornya apa?
Hello, Prasista.
Yeah, Pak.
Maybe I can change Miss Asri, having some little trouble with the connection.
Okay, because Mrs. Asri Wijayanti will change with Mr. Satria Unggul Wicaksana. He is an alumnus of the Master of Law faculty of Airlangga University. Currently, he holds the position as the head of study program in Muhammadiyah University of Surabaya, Faculty of Law. He has produced several scientific works in the form of proceedings, national and international journals in the field of international law expertise. And for Mr. Satria Unggul Wicaksana, time is yours.
Okay, thank you for your time, Mrs. Prasista. Assalamualaikum warahmatullahi wabarakatuh. Good morning for Professor Stephen Kos, my excellencies for you, and for Mrs. Jani, the excellencies, and the excellencies, Ms. Asri Wijayanti. Thank you for your opportunity. I would like presentation about my paper, about my research regarding how artificial intelligence is used to eradication as a measures to eradication of transnational corruption. I think Professor Stephen Kos in the presentation before has a very comprehensive presentation regarding of artificial intelligence. I just explain about a little bit regarding of use of artificial intelligence for eradication of corruption, especially for the corruption. I have three main topic for my presentation. For the first, how artificial intelligence and legal reform, especially for Indonesia. And the second, what is transnational corruption crime? And the third, how to use of artificial intelligence to eradication of corruption crime. I have a justification only for what is artificial intelligence. AI considered to be a branch of computer sciences, stand for method involved for solving super complex problem that cannot be solved by direct calculation or algorithm methods. That is making the computer taking a human-like approach to problem. AI systems are producing their results by engaging in some sort of synthetic computer cognition that may surpass human level thing. For the mainly use of artificial intelligence, the category use of artificial intelligence for the two topic. For the first, for machine learning, we know that in our highly digitized society, like as the current situation, artificial intelligence is embedded in gadgets, car, and also in e-commerce for the daily activity. We can search of any goods in e-commerce. And the second, the use of artificial intelligence for logical rules and knowledge participation. This is the explanation for Rena Bush in this article. Artificial intelligence is about machine reasoning. In the same time, we know that the several corruption cases that occur in Indonesia involve the jurisdiction that not in a several jurisdiction, such as a KTP case. We know that Johannes Marlim and Setia Novanto are involved of 7 countries and many banks to making a connection of crime, of corruption crime itself. And the second, we know that the cases of Garuda Indonesia and Rolls-Royce, we know that the bribery of Rolls-Royce in Indonesia, we know that Emir Sasata, the former of Garuda chairman, get a suspect of this case. So if we looking of Rolls-Royce, we looked at it not just about in United Kingdom, but also in several countries, such as in Malaysia, such as in any other countries. We know that for this situation, we looked at the prosecutor or law enforcement for the transnational corruption having some big barriers. What is some big barriers for this? The big barriers there is how to find and how to track the asset in the foreign countries. We know that the private data is just kept for bank in the other countries. We know that the asset for the money laundering maybe in Swiss or in Singapore is a very secret and strict to save a data especially for the suspect of corruption itself. So for this situation, the use of artificial intelligence is more important to support of prosecutor to know about the connection of this case for the first set, and the other set how to mechanism, bilateral or multilateral mechanism to making joint cooperation to solve for this case. Next, maybe I would like a presentation about jurisdiction, international law, and transnational crime. Jurisdiction in the sense of the actively providing privilege for a country to enforce the rule of law, giving the authority to the law enforcement, which affective people, object, and relate matter as a basic principles in upholding the sovereignty of a country. The term of multi-jurisdiction, transnational crime impact the determination of which legal mechanism are authorized to take action against transnational crime, which law enforcement officers are authorized to investigate, which court are authorized to try such case, and so on and so on. And the need for a binding international agreement was in the framework of harmonizing the criminal law system of that state, which introduced the obligation and option to prosecute a several crime, which had been the crime to men that fit within the jurisdiction of the state. So if we want to refer about the transnational crime, especially for transnational corruption, we looked at two international law documents. For the first is United Nations Transnational Organized Crime, or we know that this is a Palermo Convention. And the second is United Nations Convention Against Corruption. We know that UNCAC. For the untouched and UNCAC, Indonesia as a state party for these two conventions. I think Indonesia having a robust commitment to finding about the how transnational corruption crime is its work. For the next, if we want to refer UNCAC, I think have two UK article, and the first in Article 16 regarding about bribery of foreign affairs. It's the parties adopt such legislative and other measures as may be necessary to establish as a criminal offenses with committed intentionally the promise offering blah blah blah. In order, the official actor refrain from acting of the exercise of his or her official duties in order to obtain an undue advantage with the conduct of international business. For the Article 15.4.4, we know that the how to recover asset regarding in the foreign countries. State party for the Article 15.4 in UNCAC may consider requiring the financial institution to refuse to enter into or continue correspondent banking relationship with such institutional and to guard against establishing relation with a foreign financial institution that permitted their account to be used by banks that have no physical presence and that are not affiliated with a regulated financial group. So for the support of artificial intelligence, I think it's very support for prosecute to solve for this case. the necessary steps in the context of prosecute case of transnational corruption crime, we can refer in Article 14.2 for the ANCAC. For the first, corruption crime will commit in a planned manner in the territories of other participating countries. And the second, also matters stipulated in Article 4 ANCAC and be set aside when a corruption suspect commit a corruption crime where another country was harmed, or the corruptor reside in another convention participating countries and the corruption crime violates another parties. And the third, the investigation process, prosecute, and the next law enforcement process must work together to enforce jurisdiction between member states. How to cooperation? I think ANCAC making a sound, especially for the Article 14.8 and 49. And for the special in Article 49, the special refer is state parties shall endeavor to cooperate with their means to respond to offenses covered by this convention committed to the use of modern technology. I think the term of modern technology is AI is one of the allowable technology to use for eradication of transnational organized crime, which is we know in ANCAC in Article 49. AI and law enforcement. I think I move in AI and law enforcement. The use of AI is in several time. We know that artificial intelligence is very support to tax authority to use AI for predict risk for tax evasion. AI to uncover or detect money laundering, part of transnational organized crime, which I explanation before. And the third, business or governance to enable automatic and the assistance of AI may in some cases also reduce the risk of the fraud or corruption. AI and anti-corruption agendas, we know that in the several points, the ability of AI application to work with data sets too large for manual handling make it possible to reveal or even predict corruption or fraud that previously were nearly completely impossible to detect. AI assist procedure can replace previously corruption-prone process. I think in the conventional measures, I think we look it's very hard to know about the corruption connection. Digitization is a prerequisite for AI to be deployed in before. Only a handful of countries have the level of digitized in society to take advantage of AI, such as in UK with the SFO use of artificial intelligence to handling for this corruption case in United Kingdom. And the second, in the Kenya, we looked at these practices of use of artificial intelligence for the corruption cases and the several states. Mobile cell data or social media data are in some cases also considered to be possible data source for anti-corruption application. Privacy concerns, surveillance issue, and possibility of opaque decision-making process are ethical challenges involved in the development of AI-driven system to anti-corruption agenda. In the several practice, use of AI for eradication of transnational crime, especially for corruption, AI test to identify our risk of corruption or fraud in public requirement in Mexico and Ukraine. And in the South Africa, tax authority are looking into possibility of utilizing AI. India is more better, is discussing option to monitor social media to spot possible tax evasion. And I be able to explanation before. Transparency International UK with X-Tiger is adopting a solution with agreement with SFO or anti-corruption agency in United Kingdom to a solution to automate search in public records and stranger analytical capacity. For the Indonesia having a limitation regulation, so I can't talk anymore about the situation condition of eradication corruption in Indonesia. Why? Because we have regulation only for to adapting or to recognize of transnational crime, corruption as a transnational crime. For the first, in the Article 16 of Law number 131 is we call Eradication Corruption Act, and the second in Money Laundering Criminal Act, and the third in Presidential Decree number 13 of 2018. For the last presentation, I have three key points. For the first, AI plays a key role in anti-corruption or where digital process or mobile technology drive for a new ways to do business are discussed below. Limitation related for the second, especially about the transnational corruption, limitation related to cross-border corruption or transnational corruption need to find a solution in order to recognize of this crime as a common problem with the international community. Therefore, is the future the eradication of cross-border corruption can progressively be carried out by all countries in the world. And the third, how the integration between AI and law enforcement, especially for eradication of transnational corruption, need a comprehensive framework, harmonization regulation, and robust commitment for the other states in the world. I think this is my short presentation. I'm sorry if I have any mistake for my presentation. Thank you.
Okay, thank you very much, Mr. Satria Unggul Wicaksana, for the awesome presentation. And for the next and the last speaker, Mrs. Asri Wijayanti. She's an alumnus of the Airlangga University Faculty of Law Doctoral Program. Currently, she serves as a Dean of Faculty of Law, Muhammadiyah University of Surabaya. She has produced several scientific works and books in the field of labor. To Mrs. Asri Wijayanti, time is yours.
Thank you very much for the moderator for the time of me. Please, Panitia, to share my presentation. Okay. Pak Kodar, bisa bantu share? Halo? Dibantu Pak Satria atau Pak Kodar yang bisa? Ya.
Wait a minute.
Okay, after Prof. Stephen Kos presentation about artificial intelligence, legal ethics, and private law, and then Miss Yani Purnawanti present about the topic artificial intelligence and bioethics, and Mr. Satria beside the corruption. I will to try to presentation about artificial intelligence, reformation of labor law. Okay, Satria.
Okay, I'm sorry.
Belum ya?
Bicara itu.
It's okay. Next.
Maaf. Sorry.
Sorry, Mr. Robert. Labor law has, okay. Next slide. Labor law has not been able to provide protection for informal workers, independent workers, and work based on a partnership relationship. The situation became a big problem when artificial intelligence emerged, which could replace unskilled labor during the 4.0 industrial revolution. There are changes in the work relationship process in this era of disruption, switching in working condition, work method, and quality of work. There are parameters that change for conduction and assessment. The state must take concrete action in releasing protection in obtaining a job and additional living for humanity. What is my problem? What strategies can the government next? What strategy can the government do to take advantage and artificial intelligence for workers? And then, how regulated, how control? Next. What is the kind industrial revolution? The step of industrial revolution, the first revolution in the industrial revolution, the first industrial revolution production based on production facilities using water and steam power. And the second industrial revolution based on production based on the division of labor. Please, next step, next slide. And the third industrial revolution used of electronic and IT to further automate the production. And the fourth, based on cyber cycle system. And then industrial revolution are Internet of Things, artificial intelligence, human-machine interface, robotic technology, and digital printing. What is artificial intelligence? Two kinds artificial intelligence. Artificial intelligence is an attempt to model human thought process and design machine to mimic human behavior. Artificial intelligence is a product, next slide, is a product of work done by humans, running commands according to the state made by the designer. What is kind evolution? The first step, creating computer system that mimic human thought process to solve common problem, and the second, combining the best of the expert on a piece of software designed to solve a specific problem. This is an expert system. How about strategy in Indonesia? Indonesia strategy, making Indonesia 4.0. That is the synergy between the Ministry of Industry and related ministry and institutions such as Bappenas, Ministry of BUMN, Ministry of Manpower, Ministry of Education and Culture, and Ministry of Research, Technology, and Higher Education. Next slide. Next slide. Next slide, please. Next slide. How about strategies to anchor the Industrial Revolution 4.0? Next slide, please. There's the four kind. The first, encouraging the workforce in Indonesia to continue to improve their capability and skill, especially in using Internet of Things technology of integrating internet capability with production lines in industry. The second, the use of digital technology to support productivity and competitiveness for small and medium industries to be able to penetrate the export market through the IKM A-Smart program. The third, the more optimal use of digital technology in national industries such as big data, autonomous robot, cybersecurity, cloud, and augmented reality. The fourth, encouraging technology and innovation through the development of startup by facilitating business incubation so that more technology-based entrepreneurs can be found in Indonesia. Next slide. How about major industrial file? There are five The first, food and beverage. The second, textile and apparel. The third, automotive. The fourth, electronic. And the fifth, chemical. This is, in fact, in Indonesia, before this, used corporate social responsibility and strategy, and new strategy in Indonesia is now will be to creating share value, CSV. It's the big one of the economic which is expected to be able to provide a lever, increase competitiveness, and make a real contribution to the Indonesian economy. Next. What is this? CSV, creating share value. Creating share value, there's a concept in business strategy that emphasizes in importance of importing social problem and needs in design corporate strategy. CSV focus on doing good, and GSL focus on doing good, but CSV no. A development of the concept of corporate social responsibility. This concept was first introduced by Michael Paul McCramer, and CSV, an integration between company activities and part of the community. This is the implementation Article 4 from Trade Union Act. What is the implementation CSV? For example, palm oil leaves were photographed by satellite to determine the need for NPK and M fertilizers. Through the cultivate program, the environment is maintained and fishermen are trained to become aquatic fishermen. The community sleeping land is used as an activity for laying hands and portrayed around the company to always be creative and innovative as creative and industrial players. Providing working capital loan assistance and training to improve skill and encouraging registration of confection product with SNE. Next. They are community-based composting. Next. The community, next slide. The community collect organic waste material to make compost. The company environment and community environment are cleaned by the surrounding community so that environment becomes clean the faster it's processed into compost and processed by the company and sold in the market. There is internal for the party. The internal involves the trade union as a control function. And then the external, creating community-based employment, making foster partner partners become working partners. SV is alternative solution to work for others, to work alone, to create jobs. Next, the conclusion. Next slide. Artificial intelligence doesn't have hearts which can distinguish good and bad. Humans as creators of artificial intelligence have reason and heart. Utilization of reason and heart depends on the intention and purpose of human who create artificial intelligence. And then, can artificial intelligence be human? This is impossible. Humans have reason and heart. Akal is the same ratio scripta, and the heart is kolbu. The kolbu is word determination, a person decision. Kolbu is very influenced by good formal fight. Thank you very much. So go to moderator.
Okay, thank you very much, Mrs. Asri Wijayanti, for the awesome presentation. And ladies and gentlemen, we have listened to all the presentation of the speaker. And for the next session is question and answer. If there is question, please raise hand or can from Zoom chat, and I will read it for you. Jadi mungkin teman-teman peserta, Bapak Ibu sekalian yang mau bertanya bisa lewat chat atau bisa langsung raise hand. Nanti akan saya bacakan apabila pertanyaannya lewat chat.
Ms. Prasista?
Yes, Mr.
I have a question.
Yes. Times is yours.
Okay. Thank you very much for time given to me. I have two questions. One question is directed to Mrs. Asri Wijayanti, and the next question is directed to Mr. Satria Unggul. My first question is, it is true that artificial intelligence has no desire, has no behavior like the human being does. But artificial intelligence is created by human being. So concerning with the employment problem in Indonesia, like we know that we have many workers working for Grab, Gojek, and so on. And Gojek or Grab riders work by system or controlled by system. So they work every day based on the system created by the owner of the application system. So in this case, according to the information I get from the riders or the drivers from Grab and Gojek, they are not protected by the insurance. So they can work 24 hours non-stop. So in the contract, there is no regulation about the working hours. So according to our labor law, so the workers must work for 8 hours every day or 40 hours a week, according to the positive law we have. So my question is, how does our labor law protect the workers or the drivers of Grab and Gojek in in this case? So this question is directed to Mrs. Asri Wijayanti. And then the second question is about the corruption, or because this corruption is a part of the Mr. Satria's Unggul presentation. Suppose if the suspect of the corruptor escaped from Indonesia and then he escaped to one country, that this country has no extradition agreement with Indonesia. So how can our law overcome this case? So this is my question. Thank you very much.
Okay. Time is on me, yeah. Thank you, Mas Sohibu. Yeah. Artificial intelligence can be used by the community. For the example, you make for case Gojek motorbike. You use code and how is the protect from labor law. We have to see the form of the legal relationship. Here, the Gojek form make the legal relationship is the partnership relationship, not working relation. Partnership relationship based on Burgerrechtwetboek, Code of Civil. In this Code of Civil, maybe it's the same as a contractual on benamda kontrakten. So, as a subject to contract law, based on klausula, based on klausula for the contract in Gojek, not labor law, not employment law. This is pure private law. Okay, thank you. Maybe Mr. Satria for two questions.
Okay, thank you, Ms. Asri. Thank you, Mr. Sohibu. It's very interesting question. I think if a corruptor escape to the other countries, and it's not just about a person, I think it's asset to escape for the other countries. I think artificial intelligence is very support for, especially for the law enforcement and for prosecutor to know about what is a beneficial asset, what is jurisdiction, what is how to mechanism for asset recovery, especially for if the corruptor is from Indonesia, how the asset recovery measures to Indonesia. I think if the countries didn't have an extradition commitment, I think we can look at any other measures to joint cooperation to eradication of transnational corruption, such as we know that mutual legal assistance is one of the optional measures for the parties for the state, especially to making arrangement how to asset must be back, especially if this case for the Indonesia. How the joint investigation, how to join collaboration between prosecutor for the other state to know and to resolve for this case. I think it's many measures for the state to making this case is more better to resolve. in the future. I think this is Mr. Sokiput, and it's we can look in UNCAC to river how the mechanism, how the bilateral or multilateral mechanism for the countries to conduct or to solve for this case. I think this is my answer. Okay.
Okay, thank you. And there's question for Miss Jani. What we can expect for artificial intelligence to make contribution solving public health problem during COVID-19 pandemic? From participant. This question from participant, but I forget what's her or his name. Okay, Mrs. Jenny, can you answer the question?
Yes, thank you very much, Mbak Prasista, for delivering the question. And it is a really good question, and it is a really fun topic. So here is AI will be very beneficial if we apply the AI in the healthcare. So for example, maybe if you have a robot that can be used for example, you know that there is so many tenaga kesehatan was infected by COVID just because they have to have a contact with the patient. So I think, for example, how can we use the AI to in a COVID pandemic? So I think when in the hospital, the nurse that we can use the robot just to give the food and the medicine to the patient, not sending the nurse to go to the room. So I think that will limit the chance for the tenaga kesehatan to get infected. So I think in this pandemic, the AI will be one of the andalan. So you know that the thing that we can propose for the usage. That's maybe AI for the healthcare is a lot of example that we can bring up if we are talking about in the implementation of AI on the healthcare. And also, for example, in our academic life, maybe we can use AI to detect how seberapa menderita mahasiswa kita when they are doing daring online class. So I think maybe with the input of the data that collected by AI, and the data is more the precision of the data is more correct. So by that kind of data, so we can arrange our online classes better than now. I think maybe we'll also invite Professor Stefan Kos to give comments on how to exercise or use AI in this pandemic. Please, Professor Stefan Kos, to add my explanation, please.
Well, basically, this is not my main working area, but I agree totally. This is, of course, in the whole healthcare, it is can be very much of value, especially if we want to avoid contact between people. But this is also, on the other side, a thing which is maybe a problem in the law, the data protection and so on. Especially, we are very sensitive here with the health data. AI can collect data, a robot can collect data. The robot is not collecting only machine data. This is a question of the Internet of Things, as we have it everywhere, right? And the second point is the acceptance. So all this aspect of the telemedicine, and also then added by the AI, is a market problem. It's an acceptance problem, and I think the world is not heterogeneous in this mood to that. So I have a share from a company, a US company named Teladoc. They raised much in the pandemic time because people don't have to go to the doctor, and then there is a doctor in this app, and he will observe the person and make an interview, and then make a decision whether the person needs a medicament or which medicament it needs. And on the first sight, it sounds good. For American, it sounds good. For people in Ethiopia, it sounds good, who have no doctor in reach and maybe live in villages far away from cities. But for Germans and for Europeans, this sounds horrible. So I doubt that even the older people who are not so willing to go to the doctor, especially in the pandemic, would really prefer that. So I'm not sure if the market for that is everywhere the same. If we see Japan, they are very open for that. They already have in the senior residences puppets or robots or teddy bears which make conversation with the old people and care and call doctor when they notice, oh, there is something, some issue, and the person could have maybe a stroke or something. And German, my mother would have never put herself such a robot in her home. Yeah. So maybe it's rather a question of the market acceptance. But I agree, maybe sooner or later we will not have any choice, because we already see that everything is outsourced to the customer itself. So banks, we don't have hardly any banks anymore. I cannot go to the bank and say I want to pay in money, or so. They say go to the automat, yeah, or make the internet banking, and maybe we will not be asked. Important is the equilibrium, yeah, between the use and the danger of it. Human-centric. If the medicine is dehumanized and we have only robot doctors in the future, it will make the people sick on the other side, in the soul. Maybe I can answer a question from the chat just very fast, because it seems to me very crucial. Someone asked in the chat, I don't know if anyone read that, what if in the future artificial intelligence can really feel, so the so-called strong artificial intelligence. What then? Do we have then to accept the AI unit as something equal to human and give it human rights? This is not so much a legal question, it's a philosophical question, but it's very important for me to answer that, because it shows about the problem we have in fact, yeah, so depending on the development. Because in a moment we cannot be sure that we ever will have this kind of artificial intelligence, because the thinking structures of AI is different than the thinking structure of a human brain. But when we have quantum computers or so, who knows what we get. Just for shortly answer my opinion on that, whether we will have maybe in the future to accept an AI unit as a human or same as the human. I think, because the discussion was very interesting, my colleague Fitriatos answered, she does not believe that. It's very difficult for her to believe that, because even if the AI can think or feel, it is technology, and technology is made for man and not made equal to man. And this is a question, in my opinion, discussion which is important for you as a religious-based university, which is discussion also the relation to the religious law, yeah, and because it's very difficult to say you can never accept the AI as a same as the human being, because it is like this, because man is made as man, and technique is made for man. With that argumentation, in the time of the discussion about slavery in the United States, someone also could say the African slave can never be like man, because God made man the leader, and the slave is made for serving. What I want to say, it is very difficult to exclude philosophically AI in any case from parallel treatment to human. Even if the AI in the future could feel and suffer and will and wish. So a suffering subject should be always more protected than a non-suffering or a non-feeling subject. So this is, in my opinion, a very important aspect which we can already do with animals. Should we protect orangutans in a certain way that we give it personality, in a way, legal personality, in order to protect it, because an orangutan can suffer. Yeah, if you see in the eyes of a mother, of her ape mother who lose her baby, I saw it in South Africa. A pavian lost the baby, and she held the dead baby, and if you saw in her eyes, you can see she can suffer. So if a being can suffer, shouldn't be protected. And the more close the being suffer or the being feeling is to the human, the less it is easy to say it's just something different than the human. This is an absolute rule, and the absolute rule should be always questioned. Yeah. So for closing this is a question of ethic or of moral. For moral, it is not morally to give AI human quality in this time. Yeah, because maybe the religious moral of Catholic of the Bible will not allow that. Yeah, but for ethic, in a pluralistic sense, it is not so easy to answer that. Just to answer this question, because I think it leads us very much to the ethic aspect of all this. Thank you.
Okay, thank you very much. And for all question, because the question for Professor Stephen Kus was already answered from Zoom chat, yeah. And I think the time is over, and with the end of this discussion season, this is the end of the webinar activity. And wonderful presentation from Professor Stephen Kus about artificial intelligence, legal, ethnic, and private law, and from Mrs. Jenny Purnawanti, artificial intelligence and bioethics, from Mrs. Asri Wijayanti, artificial intelligence and reformation of labor law, and for the last, Mr. Satria Unggul Wicaksana about artificial intelligence and eradication of transnation corruption crime. And I think the time is over. Thanks to all the speakers and enthusiasts for all the participants. And I want to say thank you for university partners, for committee and participants, so that this will successful. And see you in the next activity. Prasista Maulana, and the last I say, wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much for this.
Thank you very much.
Thank you so much. Yeah, thank you so much, Pak Stefan.
I think we take a moment to take a photo. It's very important.
Pak Satria, minta tolong share screen-nya dimatikan dulu, Pak.
Because I'm sorry. So I can take my picture from my device and I can share to
sure
to your all. Okay. 1, 2, and 3.
Tutup dulu, Pak.
I think turn on your video maybe.
Share screen-nya di siapa yang share screen?
Mr. Koder, maybe having some trouble. I think I can take the photo first, Ibu Asri and Professor Stephen. Okay. Participant, please turn on your video. I can take 1, 2, and 3. Wait a moment.
The slide should be removed first. I'm sorry.
I have some.
Yeah, it still appears on the screen.
Ya, share screen-nya harus tutup dulu, Pak. Pak Koter, di mana?
I think ini
tinggal. Bisa.
Nicer if we spend together, right? In group.
Right, yeah.
Hopefully next year, yeah.
Hopefully meet in not in online or virtual, in the physically. Okay. Thank you so much, Prof. Stephen Kus. Thank you so much.
Terima kasih banyak, Pak Stephen Kus.
Thank you. Terima kasih banyak.
Terima kasih Pak.
Bye-bye. Terima kasih banyak.
Terima kasih banyak Bapak Ibu Mitra, co-host ada Eva
Terima kasih.
Universitas Muhammadiyah Mataram, Universitas Kanjuruhan dan semuanya.
Thank you.
Mohon izin. See you.
Terima kasih Bu Rena.
Terima kasih Pak Asri, terima kasih Pak Satria.
Terima kasih Bu Yayu, Bu Lili, Bu Joyce, Bapak Bu Eli.
Pamit.
Terima kasih.
Pamit. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
Terima kasih Bu Dekan. Terima kasih.
Iya, Bu Satria.
Selamat Bu Asri, selamat Mas Satria.
Afternoon Bu Eli.
Oke, selamat.
Afternoon Bu atas supportnya.